Person at the jail, what is your name?
Tammy Miller.
This is case number 254372, the people of the state of Michigan versus Tammy D. Miller. Ms. Miller, did you have the opportunity to meet with somebody from the defender's office today?
Briefly, yes.
I have a complaint that alleges that on or about October 12th, 2025 in Antioch Township of Wexford County, it is alleged that you committed the offense of operating a motor vehicle while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs. Vehicle mobilization is mandatory with a prior, and reimbursements for the cost of prosecution and governmental expenses. Do you understand those charges and the potential penalties?
Sort of, yeah.
Do you have any questions about that?
Sorry, this is my first offense, so I have no idea. I don't have any back
So-
records of this or knowledge, so
Do you
Please
understand?
be-
Do you
Yes,
understand?
yes.
No, I have a process, so I have to make sure of some things. So give me just a moment. Do you understand, based on the information that the prosecution has, that they have elected to charge you with operating while intoxicated? Do you understand that?
Yes,
Do you understand that that comes with it a potential jail sentence of up to 93 days?
okay,
It also carries with it and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs. Vehicle mobilization is mandatory if you have a prior, and also reimbursement to the government for cost of prosecution and law enforcement expenses. Do you understand that?
yes,
Now, did
Yes.
you read and sign in the advice of rights form at the jail, talk about your rights to an attorney and your rights to a trial?
yeah, at some point,
Did you understand those rights?
sure,
No, I don't need a sure. Do you understand those
Yes.
rights? Yes or no?
yes, yes.
You also have, you had the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I have no idea at this time. I haven't
Well-
been able to talk to my family, my husband, discuss
So-
any of this, so
No,
I cannot
I
make any decisions on
Ms.
my own.
Ms. Miller, I understand that. Now, you said you can't make decisions on your own. You don't have a guardian, is that correct? You're able to make
No,
legal
That's
decisions.
not what I meant, yes.
No, I know. I just want to make sure. So you can always request the appointment of an attorney, and then if you decide to go another route, you can always let the
Okay.
appointed attorney go. So is that what you want to do?
Yes, please.
What is your current source of income?
I work full-time for an insurance company.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Now, you also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. The only thing I show in your past looks like they're from 1989, and it's a violation of license plates. Actually, looks like two of them were some sort of plate violation, and one was a no operator's license on person. Ms. O'Mara, any comment regarding bond?
Yes, Your Honor. Ms. Miller lives in Meesick. She has for a while. She works remotely from her job, so she stays at home most of the time, obviously. Like she said, this is her first charge of any sort since the 80s. I would ask for a personal recognizance bond with testing at officer discretion.
Thank you. Prosecutor's office?
Thank you, Your Honor. Law enforcement interaction stemmed from the defendant driving off the roadway. She had struck a guardrail. There were signs of intoxication, and a PBT was done, which came back at a .076. We are still waiting on blood results in this case. Given that, the people would just ask for random alcohol testing at this time. Thank you.
Thank you. Ms. Miller, if I were to release you on a personal recognizance, which means your promise to come back to court, Is there anything that would stop you from coming back to court?
No.
All right. The court will release you on a personal recognizance bond with the following conditions: that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Additionally, I'm going to order that there be a no alcohol provision, given the allegations in this case, and that you be subject to random testing. Now, at some point, you will be released from the jail today. Before you are, you'll get a copy of your next court date. And then once you're released, you'll need to come over here to the courthouse, which is about 5 blocks from where you're at, and get signed up for testing through community corrections. All right. Also, within a couple of days, you'll probably be hearing from somebody from the public defender's office.
Okay.
Okay, next arraignment. Did you have the opportunity to meet with somebody from the defender's office today? I have a complaint that alleges that on or about October 12th, 2025, in the city of Cadillac of Wexford County, it is alleged that you committed the offense of operating a motor vehicle while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service. Rehabilitative programs and vehicle immobilization is mandatory with a prior. Also reimbursement for costs of prosecution and governmental expenses. Do you understand those charges and the potential penalties? Did you read and sign this advice of rights form? Talk about your rights to the trial and your rights to an attorney. Did you understand those rights? Do you have any questions for me about those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one would be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment.
All right. And what is your current source of income?
I work full-time at Cadillac Testing.
Court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf. We'll set the matter for a pretrial. That's where your attorney and the prosecutor will have a meeting to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charge, and the threat that you pose to the public. It looks like a $250 bond was posted for you already. Ms. O'Meara, any comment regarding bond?
Yes, sir, and I just asked the bond be continued, and, I mean, Mr. Valderrama is employed here in Cadillac. He has some community support in the crowd today. I don't believe that it's really necessary in this case, but I'll leave it at the discretion of the court.
Thank you. Ms. Lawrence?
This traffic stop stemmed from a couple observations that the officer had. And it was driving too slow, then he was speeding, he was observed leaving in the lane, and eventually officers realized that he had expired registration. The intoxilizer was used in this case 3 separate times. That came back at a 0.111, a 0.127, and a 0.128. Given that, I do think random alcohol testing would be appropriate. There is somewhat of a public safety concern in this case, so the people would ask for random alcohol testing. Thank you.
All right, sir, I'm going to continue the bond as previously set, but I am going to add a couple conditions to that. One is that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order, due that this was a drunk driving case, I am going to also order that you not consume any alcohol, and you'll be subject to random testing for that. Okay? Do you have any questions for me about your bond?
Am I paying something today?
No. So you get to remain out on the 250 that you already paid. And then there is a per test. When you test for community corrections, they do charge you to test. I don't remember off the top of my head what that cost is. Even though I ordered random testings, you do have the option once you go down there, if you wanted to be put on a daily blow machine, so you don't have to call in and check your numbers and make arrangements to come in. I do know that that cost for the daily blow machine is $10 a day, but they'll go through your options with you down there. Okay. You can go out to the front window where you checked in, get your next court date. You'll have some paperwork to fill out for the defender's office, and then go downstairs to community corrections and get signed up for testing. Okay. Thank you. This is case number 254100FY. We are here for alleged bond violations that the defendant failed to appear for a drug test on October 5th. That was set for a show cause, and then a bench warrant that he failed to test is ordered on October 8th and on October 10th. Mr. Bailey, have you had the opportunity to meet with somebody from the defender's office?
Yes,
You do have the right to have a contested hearing regarding these violations at which the prosecutor would put on evidence, and I would determine whether or not there is sufficient evidence to find that you have violated your bond. Also, you could plead to the allegations. I'm going to turn over to Ms. O'Mara. Have you had adequate opportunity to discuss the issue with Mr. Bailey?
I have, it's obviously his decision, but at the last time I talked to him this morning, he wanted to plead guilty and try to get this resolved today.
Is that accurate, Mr. Bailey?
yes,
All right. Ms. Lawrence, any objection to that?
No, Your Honor.
Mr. Bailey, will you please raise your right hand?
Judge, he does not have an assigned attorney yet, by the way.
There's not an assigned attorney?
I don't have one. I see he went to conflict on 9/26.
Oh. So Mr. Bailey doesn't have an attorney yet because it went to conflict. Is that accurate?
can I say something?
Hold on, Mr. Bailey. I've got to get something figured out first before we get there.
All right,
Um, So the issue I have is because it's gone to conflict, I don't think the defender's office can make any representations for the defendant as to how we're going to proceed. So do we know where things stand in regards to the appointment of an attorney?
I was looking through the notes just now, Your Honor, and I don't see one being assigned as of yet. No.
When did it go to conflict?
The last note I'm seeing. Looks like about a week ago, Your Honor.
I have it on 9/6.
Yeah, I have an email on October 1st. That was when we heard the motion to withdraw as counsel.
Oh, we actually had a motion to withdraw on this one. All right. All right. So Mr. Bailey, I'm going to very cautiously allow you to tell me what you wanted me to know, but before you do that, I don't want you to say anything yet about, I don't want you to say anything about the case. And I don't want you to say anything yet about the allegations of the bond violations. Does that make sense?
Yeah, that's what I was gonna ask you about was the violation, so I don't wanna say nothing yet.
Did you have a question about the violations?
It was more of a statement, I guess you could say.
Statement, okay,
Yeah.
all right. Mr. Bailey, did you turn yourself into the jail or were you arrested on the bond, on the bench?
I was arrested. I got picked up for it.
And how, very generally, how did you come to be picked up?
It was me and my girlfriend, we got into an argument and then,
All right, I don't want you to say anything else. Okay, I get the gist of it.
yeah.
Well, given that the defendant has expressed the desire or the want for an attorney, the fact that there isn't an attorney yet appointed, I don't believe that I can accept a plea to the bond violations. So that brings me to my next issue, Ms. Lawrence. What do we do regarding bond?
Your Honor, I'm not sure how quickly it takes to get a conflict attorney on this. I do recall that the reason for it was that Mr. RJ Shielpray, if I'm saying that correctly, was a witness in this case, which is why it went to conflict. I would like to make an argument for bond if we are setting this out for a hearing. This is not the defendant's first bond violation. Briefly looking through the file, it looks like there is multiple, all having to do with testing. And given the underlying charge, that people would like to ask for remand pending a new court date.
He is set
Oh, he's set for tomorrow.
for his PCC and his show cause on bond. Now we have this. Bench warrant.
Ms. O'Meara.
Am I allowed to speak on bond? Or I was gonna ask to speak on bond because I don't, if it were a standard arraignment, I'd be allowed to
If,
speak on bond.
if this was a standard arraignment, yes, you would, but where your office has a conflict with it, I don't think I can allow you to speak on bond. Because a conflict has been expressed, I have found that there is a conflict, have removed your office as counsel. And now we're just waiting for new counsel to be appointed. It looks like that happened back on October 1st.
And I respect that. I just worry that he won't be able to make a statement due to the, and then I have talked to him and I don't believe.
So Ms. O'Meara, let me ask you, how do we get around the conflict issue then? If you're bound determined to speak, how do I get around the conflict issue?
And I'll withdraw this because I don't have a specific argument. I just don't think that there is a conflict issue on the arguing for his bond right here, not the bond violation, just the new bond to be set potentially. And so that's my opinion. I respect that it's probably not correct.
Mr. Hartel, is there any indication as to where we're at? I know you said you were going through the notes. Do your notes indicate, because I'm not familiar with your system, do your notes indicate that such and such attorney's been contacted and rejected, or?
Normally it would, but I'm not seeing that in there. So the short answer is I do not know.
All right, fair enough. What time is he set for tomorrow? 10:30 PCC.
Or no. I think it went to. Mhm.
Yeah, it's a
It's a
prelim
prelim.
that too.
Because we.
With military.
Yeah.
Mr. Bailey, you're currently set for a preliminary examination for tomorrow at 2 o'clock. However, that's probably likely not going to happen because there's no attorney appointed for you yet. But what I'm going to do is I am going to release you on your personal recognizance, which means I'm going to release you. I'm going to order that you appear tomorrow at 2 o'clock.
2
Court.
o'clock. Okay, okay.
Whether you have an attorney or not, I'm going to order that that's what you do. All right?
Oh.
And then we'll see if we've got some more information tomorrow at 2. Now, in between time, it's probably too late to do that now, but it's very likely you could be called in to test tomorrow. And if you are, you're going to be.
Can I say something with that? Because the reason why I wasn't able to make I know I missed a couple, that's on me. That's I'll admit, that's my fault.
Yep, no, I get that, but Mr. Bailey, we're to the point, and this is where things get tricky, is because you're to the point where you want to tell me what happened, and I don't want you to do that yet, because I don't want you to, essentially by doing that, you're going to tell me that you're guilty of the violations, and I don't want you doing that without the advice of an attorney. Now, from what you're telling me, I'm probably, and I might read between the lines here, but I'm guessing there's some sort of transportation issue or communication issue. But what I'm going to tell you is, if you're ordered to test, you have to be here to test. All right?
All right. Yep.
All right, so for today, I'm going to indicate that we arraigned on the bond violation. I'm releasing you on your personal recognizance. Well, so I'm going to reinstate that the bond is previously set and that you must appear tomorrow at 2 PM. And we'll address the attorney issue then as well.
Alrighty,
All right?
yep.
Do you have any questions about that?
No, if I have any, I'll make sure I ask them when I see you tomorrow.
Okay, all right, fair enough. Next arraignment, jail.
His rec.
Lisa 6. Good afternoon. This is case number 254374, the people of the state of Michigan versus Lisa Renee 6. You're here for an arraignment. Ma'am, did you read and sign this advice of rights form?
I signed it and put my email on there.
Can I get you to fill out your address and phone number on there as well? Do you have a pen? There's one in the container right down there at the end of the. The information that you just put down, is that your correct contact information?
Yes, sir.
Did you have the opportunity to meet with somebody from the defender's office today?
No, sir.
I have a complaint that alleges that on or about October 10th, 2025 in Antioch Township of Wexford County, it is alleged that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. But also consecutive sentencing may apply if it happened in a place of confinement. Do you understand those charges and the potential penalties?
I don't understand the last part you said.
So essentially, if this happened in jail, which I'm
Oh,
sure it
no.
didn't, you could be, if you were serving a jail sentence, they would run separate from each other.
Got it.
Other than that, do you understand the charges and the potential penalties?
Yes, Your Honor.
The advice of rights form, did you understand that, those rights?
I didn't quite read those.
All right, so we'll go through those together. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You have been brought to court on a misdemeanor charge. You have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. Also, to have a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney, and if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney, and you can test your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official will not comment on your refusal to testify. And also to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind. You'll give up the rights that we just went through. You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence or is permitted pursuant to court rule. If the sentence includes incarceration, if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver, if you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights?
Yes, Your Honor.
Do you have any questions for me about those rights?
Oh, yeah.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one would be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request appointment,
And what is your current source of income?
a full-time job.
Court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will have a meeting to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charge, and the threat that you pose to the public. Looks like a $500 bond was posted over the weekend.
Yes.
Counsel, I showed the defendants passed an 11 operating without security, 13 operating while visibly impaired, 24 operating while intoxicated, and in 12 there was a 4A case. The praxis scores her at a risk level 1, so low risk level. Any comment regarding bond, Ms. O'Meara?
I obviously didn't have a chance to speak with her, but I would say that she fears down her own cognizance, and I'd ask that her bond be continued.
Ms. Lawrence?
Thank you, Your Honor. The people do not oppose a PR bond. We would just ask for a no contact order in this case. Thank you.
Thank you. Ms. Six, I am going to allow you to continue on the $500 bond that you've already posted. I am going to order that you appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. I'm also going to order that you not have any contact with William Stokes. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. Do you understand that?
Yes.
I'm also going to order that you not act in any threatening, intimidating, or harassing behavior, and that you not purchase or possess any firearms or weapons. Any questions about your bond conditions?
No.
All right, you can go to the front window where you checked in, get a copy of your next court date, and you'll probably have some paperwork to fill out for the defender's office. All right, thank you. Person at the Wexford Jail, what is your name?
Douglas Willett.
This is case number 254160 SM, the people of the state of Michigan versus Douglas Lee Willett. We are here on an arraignment for a alleged bond violation. The allegation is that the defendant violated the no contact order with Andrew May on October 12th. That he was in the same vehicle as Douglas May. Mr. Willett, you do have the right to have a contested hearing regarding that bond violation, at which the prosecution would be required to show to the court that you were in fact in violation of that bond condition. If I do find you in violation of the bond condition, I could revoke your bond and you could be held without a bond. Do you understand that?
Yes, sir.
We have a co-defendant in this case as well. Ms. O'Meara, do you know, has one of these cases gone to a conflict attorney? Mr. Willett has? All right. All right, so Mr. Willett, I'm being informed that your case has been sent to a conflict attorney and we have not received an appearance from an attorney yet. And we are next set for a court date on October 29th. I'm not going to ask you whether or not you want to admit responsibility to the bond violation, because I believe you should have the opportunity to discuss that issue with an attorney. So I'm going to turn to Ms. This is your case, Ms. Lawrence?
I don't believe this case has been assigned to anyone in our office yet, Your Honor. They were just waiting last week.
Do you have it today, though?
Yes.
Any comment regarding bond?
Yes, Your Honor. I believe was bond originally set at a PR bond.
It was PR bond with the standard conditions and no contact with Robert Lockhart or Andrew May, along with no threatening behavior and not to purchase or possess a firearm or weapon.
The people are going to ask for $1,000 bond. In the meantime, we may be a hearing or an assignment of an attorney on this file. Like I said, the defendant was just arraigned less than a week ago and has already broken the no contact order with his co-defendant in this case, which just remained in court. Both him and his co-defendant have essentially jumped or assaulted the victim pretty badly. And they were found in a vehicle together less than a week after the court had ordered the no contact order. Given that, I would ask for $1,000 bond. Thank you.
All right.
Looks like Mr. Pickwick picked that one up.
Mr. Pieknik has this one?
Yes, we just.
So he does have an attorney.
We don't-
We
At
don't
least
have
in
an
theory, he
appearance
has an
yet,
attorney yet. We
but-
just don't have an appearance. All right. Can we try to get it set for tomorrow?
Yeah.
Mr. Willett, what I'm going to do, I've been informed that the conflict administrator has assigned your case to an attorney. They just have not filed an appearance yet with this court. So what I'm going to do is we're going to try to get this set on tomorrow's docket for the court to address it. Hopefully we can have your attorney present at that time. If not, we'll have to make some adjustments to the schedule. But for the meantime, because this is a violation of the no contact order, although I understand it's a violation of the no contact order in regard to the co-defendant and not the alleged victim in this case, but it is still a violation of the no contact order. I am going to, for today's purposes, remand to the custody of the Wexford County Jail until we can have that, hopefully have some contact tomorrow with your attorney.